What up? What up? All right. Um, I do think that this particular screencast will be kind of short, although I've said that a million times. Um, so let's get started, and maybe it will be under 10 minutes. Let's hope so. The Federal Judiciary, again, the third article of the Constitution establishes, um, as they put it, a supreme tribunal, which essentially means a court. Uh, Again, it does not clearly state out the three levels of the court system at the federal level. It just says one tribunal or court, which you would assume to be the Supreme Court. What the Constitution says is that Congress can establish or set up uh, any court below the Supreme Court. So when we talked about today the Circuit Court of Appeals and below that the district courts, those were set by Congress. And Congress also sets, for example, a military court. You don't really need to know that, but you do need to know that Congress has the ability to establish any of the lower level courts. They also have the ability to establish the amount of justices or judges that serve at each level. So, right now, the Supreme Court, for example, which we'll get into further detail in the next screencast, has 9 justices. In theory, the Congress can increase, but I don't think that's going to ever happen. Again, essentially, the courts have the ability to set public policy. And we talked about the gay marriage case from this past term last year, in which they ruled that individuals of the same gender may get married. They are essentially establishing public policy. So they have pseudo, or I don't know what term I want to use, but they kind of have the ability to set laws. They can't write laws, but they can interpret whether a law violates the Constitution or not. So they do have a tremendous amount of power in regards to establishing public policy or law. Again, we've talked about statutes means law, and statutes are often very, very vague or broad, which means that they're unclear. And a lot of times the courts have to kind of fill in the blanks in regards to providing clarity to pieces of legislation and public policy. The court has made or ruled many state and federal laws in its history as unconstitutional. So when they make a ruling, they can wipe out, again, because it's current, in regards to all of the states that had definition of marriage laws between a man and a woman. They will wipe out all of those decisions or all of those pieces of legislation or referendums with one decision that they made in June of this past summer. Sometimes a court will reverse itself, meaning change a previous decision that they have made. That's very, very rare. As a institution, they don't want to be constantly going back and trumping or overturning previous decisions. So they are very careful when they do that. So when you talk about a case such as Plessy versus Ferguson, which established separate but equal, that was overturned with Brown versus Board of Education, which desegregated schools. So there are examples in which the court has gone back and kind of overturned or overruled a previous court's decision. The gay marriage case overturned a previous decision, Bowers versus Hardwick, which said that gays and lesbians did not have rights. They did not have protections in the Constitution. So there are a few instances where, as time progresses, the court will overturn a previous decision or precedent. Precedent is a key term in this unit. Precedent means what the court established with a decision. So when you talk about Brown versus Board of Education, they established A, schools should be desegregated, but also B, that regardless of race, individuals are treated equally in our society. Jurisdiction just simply means your ability to hear a case. So different court layers or levels have different jurisdictions. So, for example, if you commit a crime in Elmhurst, you will be tried in DuPage County Court. It's their jurisdiction. If you commit a federal crime, you will be tried in a district court. It's their jurisdiction. So, who has the ability to determine whether you've broken a law is what jurisdiction essentially means. Exclusive means only one court or only one level of the court system has the ability to hear a case. Concurrent means at the same time. So, for example, you may commit a crime that may be also a state offense and it may be a national offense. So there are some laws that apply at both the state and the national level. So you could be tried in more than one court. It's very rare. Original means the ability to hear the case first, or the original court and where it was heard. So, for example, if you break a federal law, it's going to be at the district court level. You can then appeal, if you don't like the decision, to the Circuit Court of Appeals. That would be the second step or the second time a court has heard the case. That would not be original jurisdiction. Appellate jurisdiction or on appeals is when you've heard a case after it's been heard at a lower level. Almost every Supreme Court case is on appeal. Jurisdiction of the federal courts, anytime there's a constitution issue, a federal law, a treaty, the situation will end up in the federal courts. Some of these are not so important. If something happens on the sea, maritime means on the ocean, that would be the federal courts, because obviously the ocean isn't unique to one particular state. One that is a little more current is 3C, which is disputes between two or more states. Right now, I think it's Nebraska and Oklahoma want the Supreme Court to invalidate Colorado's legalization of marijuana because they are claiming that it is a undue burden on their judicial system or their criminal justice system, because people they're claiming are leaving their state, go to Colorado to get marijuana legally, and come back to their state. And of course, it's illegal in their states. So they're arguing that because Colorado made marijuana legal, that it is an undue burden on their judicial system. So the Supreme Court has not agreed at this point to hear that case. But if there's a dispute between states, that is the original jurisdiction of the federal courts. Obviously, if the U.S. is a party or you're claiming the U.S. government has violated your rights, it's going to go to the federal courts. And we'll move on. So again, we talked about this today. These are the three layers of the federal courts. The first layer is district courts. That's if you've broken a federal law in the vast majority of cases, and they are usually original jurisdiction, meaning the first time the case has been heard is at the federal district court level. There's a lot of them in the states. I believe in our state we have two. I believe Springfield and Chicago are the only two locations. The Court of Appeals, which we'll look at a little bit later in regards to the map we also talked about today, is the second level of the federal courts, and that was established by Congress, as was the district courts. These courts do not have original jurisdiction, Court of Appeals. They are strictly appellate or on appeal. So again, if you feel that a state Supreme Court has violated your rights, you could appeal to the Court of Appeals. They don't have to take your case. Or if you feel like your rights have been violated at the district court level, you could again take it to the Court of Appeals. These cases are usually heard by three judges and made a decision. So you'll see like 2-1 or 3-0 decisions. If you are unhappy with the Court of Appeals decisions, you can ask for the full circuit to hear it. So in each of the 12 circuits, they have, I would say about 15 to 16 judges. They don't have to hear it, but they sometimes will hear it if you choose to request that. So then you'll appear in front of all of the justices in that particular circuit. I guess maybe we should go to one of the circuits. Let's do that now. 12th Circuit Court of Appeals. Oh, this is a horrible website. No links whatsoever. Unbelievable. U.S. Court of Appeals. Can I get a link, please? Maybe a link? No, give me a link. Oh, this is so annoying. Well, you see, one thing that's not so annoying is it'll tell you how many judges are in each circuit. So each circuit is different. Some circuits have a lot more states, so they would have more justices. Let's try to go to the Ninth Circuit, which is Hippie Coast. What I like about the Ninth Circuit is they actually have video. Each of these circuits at each level of the court can determine whether or not, well, hello there, Jacqueline, whether or not they're going to have audio. Well, I think all of them have audio. Whether or not they're going to have video. And what's nice about this circuit is they do have video, which is pretty cool. I really like it. No live, of course, not at 7:30 at night. Oh, they got a little YouTube page. Stepping it up. I wish I had a clue about what these particular cases were about. Unfortunately, I don't. I don't know who Marguerite is.
Good morning, Your Honors. May it please the Court, Colleen Flynn for Plaintiffs, Appellants, Marguerite Heiken, and the Military Law Task Force. I would like to reserve 4 minutes for rebuttal.
Okay, counts down. Keep track.
Oh, fantastic. Thank you. I would like to begin by explaining the ways in which the District Court here abused its discretion. Under the clear
and present danger, so this one deals with speech. I can tell you that. We'll talk about that later this week. But here you have 3 justices from the circuit. I have seen this circuit have the entire circuit, which I don't know how many judges there are, but here you only have 3. And most of the time, these cases are heard in front of 3 justices. Again, if you do not like the decision of the 3 justices, they look a little upset. They don't look like they're having a very good day. Then you can certainly ask them to hear in front of the entire panel of judges. I wish I knew one where it was in the entire panel. I have seen it before. We're not going to spend any more time on this, but again, so all of these circuits established, and let's see if they have about the court. Okay, this is getting ridiculous. I just want a list of the judges. Maybe I should have looked at this ahead of time, but you'd think they'd have an easy link. I want the entire Federal Judiciary. But again, let's go back. Again, the Court of Appeals is that kind of intermediate level in the federal system. The highest level is the Supreme Court, which we're going to go into more detail in the next screencast. Again, very, very rarely do they take a case, usually about 5% of the time. So if you don't like the decision at the Court of Appeals level, your chance of getting the Supreme Court to hear your case is going to be very, very slim. There has to be a key constitutional issue or, again, a conflict between the different circuit courts. It is the highest court of the land. There is no higher court above the Supreme Court. 9 justices, VIPs. We'll just leave it at that. Let's see here. Most federal cases, again, begin at the district court level and very rarely proceed to the higher levels. Very, very rarely. And again, if you look at the the circuits, You'll see that some have more states than others. And again, if a decision is made in a circuit, we are in the Seventh Circuit. I don't know why I thought we were in the Fifth. We're in the Seventh Circuit. If a decision is made by this circuit court of appeals, it only applies to Wisconsin, Illinois, and Indiana. And again, with the gay marriage cases, you had different circuits saying you had an inherent right, a constitutional right to get married, regardless of gender. And all of a sudden, you had the Sixth Circuit, Michigan, Ohio, Kentucky, and Tennessee, rule that you did not have an inherent right. If you have one circuit that makes a decision that goes against all of the other circuits, it's very likely the Supreme Court will take your case because they don't want different rules of law throughout the country. If all the circuits are making the same decision on similar issues, then they're cool with that. They don't need to take the case because all the circuits are agreeing. So when you talk about the Supreme Court, they're not going to hear a lot of the cases from the circuit court level. Again, about 5%. Some years it's higher, some years it's lower, but about 5%. So those are your three levels of courts in the federal judiciary. Peace.